Everything that is explained in this video is summarized from CoinMarketCap. Now take a look at this. Ripple XRP gains ground as court approves confidentiality in said case. A new legal development has resulted in Ripple achieving a tiny success in the ongoing dispute that it is now engaged in with the Securities and Exchange Commission, SEC of the United States. Both parties have submitted confidential papers, and Judge Analisa Torres has agreed to comply with their request to have those information sealed. There was a consensus achieved on this matter on March 20th, 2024. Protected discussions regarding the settlement records that potentially include sensitive financial information from Ripple's accounts after the SEC's litigation alleging XRP sales in December 2020 have been sealed. These records include prospective settlement conversations in the case. In order to protect confidential financial information, Ripple and the SEC have both advocated for the sealing of the transaction. The acceptance of the joint request by the court paves the way for a revised timeframe and processes for the redaction of documents connected to the settlement. By reaching this compromise, the parties will be able to shine light on the fundamental grounds of conflict between them, while at the same time keeping any critical business information hidden from the public eye. Eligibles and opportunities for settlement that have been revised. The revised schedule includes the addition of new dates for the filing of papers and the negotiations over redaction. Following the filing of the opening brief by the SEC on March 22, there will be a period of time for discussion regarding redactions. It is anticipated that redacted briefs will be made available to the general public, with the Securities and Exchange Commission releasing theirs on March 26 and Ripple on April 22. It is anticipated that the extended schedule, which has a response deadline of May 20, will make it possible to conduct a comprehensive analysis of the contending grounds for settlement, thereby increasing the likelihood that the disagreement will be settled peacefully. The possibility that Ripple and the CC could reach a settlement prior to the matter being brought before a judge is a topic of widespread speculation among legal observers. Potential consequences for the market performance of XRP. There is no denying that the legal struggle has had an effect on the market value of XRP, as evidenced by the recent increase of 4.43 in response to the most recent developments. In spite of this, the long-term consequences on XRP's performance are yet unknown, and they are directly connected to the scrutiny that the SEC continues to exercise over its sales. Although an earlier verdict in July 2023 determined that XRP was not a security under U.S. law, providing Ripple with some relief, the resolution of the lawsuit, which may not come until 2025 deadline, will have a decisive influence on the value of XRP. In the ongoing legal battle that Ripple is engaged in with the Securities and Exchange Commission of the United States, a new development has occurred. Judge Analisa Torres has granted permission for both parties to submit a motion to seal private papers that they have jointly provided. On March 20, 2024, this request was agreed upon and granted. Consider the many approaches to settlement in the court's ruling contains material that pertains to the many options that have been presented for the settlement of the matter. In December of 2020, the Securities and Exchange Commission filed a lawsuit against XRP sales. These details may include Ripple's financial statements and specifics surrounding the lawsuit. Both Ripple and the SEC have defended the decision to partially conceal these records in order to protect sensitive information regarding financial activities. A change schedule and redaction process for the settlement briefing are both possible as a result of the judgment made by Judge Torres. Because of this, the public will be able to see the fundamental points that both sides have presented, with the exception of any details that are commercially sensitive. In addition, a decision has been made that calls for a time of negotiation between Ripple, the SEC, and any third parties that may be engaged in order to decide the particular content that would be removed from public files. Recent deadlines and the possibility of a settlement, new deadlines for the submission of summaries and responses have been established as a result of the amended schedule. Following the presentation of the opening summary by the SEC on March 22, there will be a period of negotiation regarding redactions. It is anticipated that modified copies of the summary will be made available to the general public on March 26 by the SEC, and Ripple will do so on April 22. The 20th of May has been designated as the deadline for sending in response summaries and motions to seal information. During this extended period of time, it is possible to conduct a comprehensive evaluation of the arguments for settlement and to consider the potential of resolving the dispute. Ripple and the Securities and Exchange Commission are expected to negotiate a settlement deal before the case gets to trial, according to individuals who specialize in the law. This week, the current SECV Ripple issue will once again be the primary center of attention for investors. There will be a version of the remedy-related opening brief that has been redacted that will be released by the SEC on Tuesday, March 26. For selling unregistered securities to institutional investors, investors anticipate that the Securities and Exchange Commission will make a case for a punitive disgorgement. Ripple was found to have violated Section 5 of the 1933 Securities Act when it sold unregistered XRP to institutional investors, according to a decision that was handed down by Judge Torres in July of 2023. In the wake of increased scrutiny, the Securities and Exchange Commission (SEC) will issue the opening brief that has been redacted. An investigation into suspected conflicts of interest involving cryptocurrency within the Securities and Exchange Commission is getting near to being finished by the Office of Inspector General. Like, there is a possibility that the SEC's plans to appeal a second verdict from July 2023 could be affected by evidence of financial conflicts of interest. The third component of the Howey test was not satisfied by the programmatic sales of XRP, according to the decision made by Judge Analisa Torres. The probe pertains to William Hinman, who served as the director of the SEC in the past. During his time as a crypto regulator at the Securities and Exchange Commission, Hinman said to have earned millions of dollars from his prior job, Simpson Thacher. When Hyman left the SEC, he went back to Simpson Thacher to continue his career. The statement that Bitcoin and Ethereum are not securities was made by Hyman in a lecture that received a lot of attention in 2018. A group that advocates for enterprise Ethereum is one that Simpson Thacher is a member of. The matter between the SEC and Ripple will be subjected to additional scrutiny by Empower Oversight on Tuesday. During the live broadcast on Crypto Law, the founder, Jason Foster, and the president, Tristan Leavitt, will talk about the IG report and the cases filed by the CC. Comparing the SegDevNeo over oversight in a lawsuit filed on March 18, Empower Oversight demanded additional records linked to cryptocurrency conflict. During the announcement of the lawsuit, Empower Oversight stated through their sluggish response to our Freedom of Information Act request, the Securities and Exchange Commission is obstructing Empower's oversight into SEC officials who have conflicts of interest regarding cryptocurrency concerns. It is the responsibility of the public to have access to all documents that pertain to the manner in which these public officials broke ethics guidance and the manner in which the agency failed to hold them accountable. On March 14, Empower Oversight made a request for records that pertain to infractions of ethical standards that may have occurred. The probe was broadened to encompass records relating to former SEC Chair Jay Clayton as a result of the request that was submitted on March 14. Reportedly, after leaving the Securities and Exchange Commission, former Chair Clayton relocated to One River Asset Management. There is a hedge fund called One River Asset Management that focuses on Bitcoin and Ethereum. In the response to the Freedom of Information Act, Clayton's assertion that Bitcoin is not a security was emphasized, and Hinman's remark regarding ETH was reaffirmed. Links between Clayton and companies associated to cryptocurrencies date back to the year 2022.